So I was on mute.
Attorney Coleman, can you approach? Am I in trouble?
Well, happy Father's Day, all fathers. Yeah.
Appreciate you too.
I'm here for Mr. Travis. That's when you asked me about something.
I said, for that. signed up.
All right, and it states that defendant will pay or vacate plaintiff $3,345 on or before July 31st, 2023. Defendant will start paying monthly rent on July 1st, 2023, and plaintiff will inspect and repair if necessary hot water tank and kitchen sink. Plaintiff will make available for pickup recertifications in office for 2020, 2021, and 2020.
2022, Your Honor, I'm sorry.
Okay,
Agreement, John.
all right, court will sign this. Please wait around for your paperwork. Do you have any questions?
Thank you, Judge. Always a pleasure again.
You too, have a great.
Yeah, happy Father's Day.
Bless that.
Oh, it's a pleasure.
I'm getting some water in the grass. I'm not walking out. I want to keep my. What I do now?
You give me that call back?
I never took it.
Okay. Making sure.
Oh, they sitting in. Getting scary. No, I'm double nickel now, so I'm old.
Sitting away from the AAR.
No, AAR starts and you start any AARP. It ain't just for old people. AARP ain't just for old people. No. Signed up early. I know my wife signed us up. She ain't 50 yet. She signed us up years ago. Some discount.
Go, sir.
Like me to handle sister council her as well. Oh, make another copy of the original for the tenant. Oh, and I'll get them both.
The next time you're here every day.
Yeah.
All right. I might set it here. I might.
I guess it doesn't change. It doesn't change the judgment.
Huh?
It doesn't change the judgment unless you set it aside.
Right. The argument. And it's a land contract, so it's still a little time left.
If you do set it, you send me a copy of the motion I never received.
Absolutely.
If you have a good copy, I'll make a copy of that.
Oldie. He's an oldie. He's an oldies, man.
Thank you. Actually, I know the term.
Oh,
I can make a notation.
I mean,
We just give her the original.
Those
Thank
are
you.
ones that, the other clerks
Here,
are
here.
finding
I like-
that wasn't signed. That's from a while ago.
Good morning.
Right.
Are you here for 11 o'clock case?
That's fine, that's like.
Calling case number 233473770. This is 6877 Falls LLC versus Jamaica. Hugh. Can I have a hearing?
Good morning, Your Honor. Shakina Melbourne, P number 78958 on behalf of
Said on behalf of,
the plaintiff.
okay. Good morning. Counsel, do you remember why this case was adjourned?
Because at the last hearing, the tenant showed up after the case was filed. Oh, he was having issues with Zoom. He
Okay,
kept coming in and out 7 times, and so it was scheduled for us to come in person, and maybe that would help with any electronic device issues he was having.
okay. And I believe parties received notice to appear today. There's a proof of service in the file. A mailed copy was sent for today's hearing. And defendant has failed to appear. Who would you like to score?
Your Honor, we're receiving a default judgment at this time.
And do you know the rent due, total amount of rent due right now? Do you
I
know
can
if
look
there's,
it up. I don't have.
do you know if there's any rent due?
Yes. There's rent due, but I don't have the exact number, because I don't have the entire file.
And I can get you, I can allow you to view this file. I just know that this amount, the total rent due was $900 at the end of April. So it wasn't that significant. So you could verify before we put a judgment in there.
I just gotta look on my phone.
Okay. All right.
No, I just want to grab my phone, and I can tell you.
Okay, we'll recall it shortly. What are the court costs?
It would be 180.
Right?
You tell me the default date, so I can.
Defendant must vacate by June 26, 2023, or writ of eviction may issue after that date. All right, that concludes the matter, ending in 7370. And it failed to appear, default judgment was granted in the amount of 2,700 or 2,880. And it must vacate or pay by June 26, 2023. And here it is.
What day is it?
Say what kind of case it is.
Yeah, the 23rd, still right here, the 23rd. Over here. 7/6. It's not going. Right.
All right, have a great weekend.
Thank you.
Oh, well, you're still there.
Yeah.
I need them here.
Bless you. CR436. This is Holding Block LLC versus Filthy Americans LLC and all occupants.
Good morning, Your Honor. Number 80522, appearing on behalf of the plaintiff.
Good morning, Your Honor. Shakina Melbourne, P number 78958, on behalf of the commission.
Good morning, counselors. We were here last Friday, right?
Monday,
Okay. We're this month?
yes.
Okay. It was recent, and I requested another hearing because there's a little disconnect or possibly a few issues that we didn't have the answer to, but we're back.
You did indicate, Your Honor, that you were interested in speaking with our clients directly via Zoom to inquire about whether or not these behind the scenes agreements have been taking place. My client is actually logged in.
I see Ryan Zechner on behalf of Holding Block, and I'm assuming that's Mr. Rockwell.
Correct.
On behalf of Filthy Americans. So, Mr. Rockwell.
Yes, sir.
Can you state your name?
My name is Herbert Turner.
All right, and do you own Filthy Americans LLC?
Yes, sir.
All right, and do you swear to tell the truth and nothing but the truth?
Yes.
All right, thank you. And let's see. Is it Zechner?
Yes.
Okay. I don't see him right now, but he did log in earlier. All right, so parties indicated, I think it was you, Ms. Attorney Melbourne, that indicated that there was a payment plan or some type of arrangement that existed. And I knew both attorneys represented that. However, well, you represented a different position,
Yes.
that there wasn't a payment plan. So I thought it'd be best to have the plaintiff and the defendant come in to just clarify issues if there were any, and then we can come up with the resolution today.
Yes, Your Honor, I do have a copy of the text messages received from sister counsel. And it just expresses that, proposals back and forth, but ultimately no agreement related to these text messages here.
Okay, you provided that to
Correct.
attorneys.
And yet there was some additional text messages between, I'm not sure who Brian is, but David Grasso, who has been alleged to be primary representative of Holding Block for the duration of the lease. And yesterday, there was communication specifically asking, hey, are you gonna pay the $1,000? It's June 15th. This is the same dispute that was here in the first place, that there was an agreement for $1,000. That was June 15th. In theory, they were due the 1st. My client asked for the 15th of the month to make this $1,000 payment, June, July, August, and September. He was never given a yes to the June 15th date. Yesterday was June 15th, and David sends a text message saying, are you going to pay the $1,000? My client says, well, wouldn't it be $750? Because you already took out $250 at the beginning of the balance of the $750. If there's no agreement for $1,000, why would the landlord ask for the $1,000 on June 15th?
Madam, I prefer that the text message sister counsel is illustrating that be referred to directly, because it's not an entirely accurate depiction of this conversation that took place yesterday via text message. Ultimately, the bottom line is, Your Honor, behind the scenes, there are offers going back and forth. Ultimately, nothing was agreed upon by both parties, nothing was signed. There has been no addendum to the lease, and my client can't be forced to agree to terms that are being proposed. My client wishes to pursue or to proceed with seeking a judgment for possession. He has no confidence in the tenant's ability to pay, and he does not want to waste any additional time. And this is our fourth hearing addressing this issue, Your Honor, whether or not certain agreements were reached behind the scenes with respect to payment plans.
If I may, Your Honor, it was plaintiff who proposed this initiation Sister Council would show you the copies of the printed text messages, she has all of that. Where it was the plaintiff that even proposed the payment plan in the first place. In all of the proceedings between these two people from 2020 till today, any lease addendums were drafted by plaintiff. Plaintiff has never sent an addendum because plaintiff has never completely said, okay, here's a copy of the new lease addendum. However, it didn't change the fact that as of January of 2023, when he agreed to make taking payments of $250 by ACH payments, there was no addendum then, but he continued to take the ACH payments as late as June 2nd of every month from January to June. So is there not an agreement by plaintiff simply not saying yes to the June 15th date of that $1,000, yet he's continuing to take funds?
Your Honor, ACH payments are initiated by the sender, not the receiver. My client has absolutely no control over the defendant's bank account. There has been a total of two separate $250 payments that were automatically sent via ACH, subsequent to the demand notice having been mailed. And as I indicated at the last hearing, my client is ready and willing to refund that amount.
Okay, has any ACH payments been sent and accepted beyond April 20th?
There was one, Your Honor, I have a copy of the ledger if you'd like to see, and I have highlighted the parts showing the ACH payments.
Because the notice was dated in March, there was a payment that came out in April, a payment that came out in May, and a payment that came out in June. My client does not submit payments to the plaintiff withdraws funds out of the account.
Okay, so is the plan, was the payment in April? Well, this was April 1st, so that doesn't count. Well, it does count. So April 1st payment and a May 1st payment. Were those returned?
They have not been returned, Your Honor, because as I indicated, my client is ready and willing to return both payments. He had no control over putting a stop to these ACH payments into the bank account.
All right, I just really, okay, Mr. Zechner is here. Am I pronouncing your name right?
It's Zeichner, Your Honor.
Mr. Zeichner, good morning, sir.
Good morning.
And my apologies for interrupting, but if I may, Ryan is one of the high-level managers in the company. He's not the actual owner. The actual owner, his name is David Grasso, and he's the one that has been engaging in these text message conversations. Ryan does have personal knowledge, and we did just have a three-way call and discussing whether or not David had sent those text messages, and he did indicate that he did send them. But I just wanted to make sure you knew Ryan was not the actual owner.
Okay. You want to swear me? I swear. Do you swear to tell the truth and nothing but the truth?
I do. Yes.
Okay. And do you work for Holding Block LLC?
I do.
Okay. And do you have knowledge about their property management?
I'm the head of property management nationally for the company. I do.
Okay. And would that role include collecting rent?
It's something that I oversee, yes.
Okay. All right. So we scheduled this hearing today to get some clarity because there are ACH payments. This is a termination of tenancy case. A termination of tenancy case means that parties are terminating the tenancy and do not want any rent. However, two payments were sent over and accepted after the notice to terminate was sent over to the defendant. So based on Park Forest, there's a case with precedent, it's Park Forest, that states simply, if I may paraphrase, is if you accept rent, then a termination, then it has to either be converted to a non-payment of rent, or the money must be returned. But if there's a reasonable belief that payments can be made, then it's confusion for the defendant. So I wanted to clear up any confusion that may exist, and I wanted all parties to be on the same page. I want to come to a resolution in this case. So, is there any offer that exists or any arrangement that exists where filthy Americans can redeem their tenancy?
Your Honor, we would need a substantial payment from filthy Americans. There's over $20,000 balance here. We're paying a mortgage on the property, and most of our tenants are paying the rent. What Mr. Rockwell's paying doesn't help us, doesn't enable us to pay our mortgage. We've got to pay that out of pocket. This couple $100 here and there, it is not the rent. These recent payments, they can be returned. They're electronically initiated. For whatever reason, they were initiated and collected after this action was taken, I believe in error possibly, and we can certainly return them. But we're really far apart here. You know, we can't proceed on a promise. There's a lot of past due rent here. There's been sufficient.
I have a lease ledger, and I will let you continue. I just wanted to get that amount and throw that out there. How much is currently owed? Is it 22,704?
It's $22,454.81.
Okay.
And Your Honor, as you can see on the ledger that I provided you with, in the past year, the defendant has only paid $1,800 total since last June.
Yes, you may.
From 2020 till today, ACH payments were not even a part of the process. All payments were being sent to the landlord. ACH became an option when a representative from the landlord in January of 2023 offered that option to my client. From there is where this 250 came about. From there is when everything was fine, and then a notice of quit shows up shortly thereafter.
When you say everything was fine,
In the sense that there's been communication, any discrepancies, no lease violations, nothing took place.
but was there money owed?
Yeah,
So there's a lease violation.
true, but I'm saying there's no communication between the parties, like how they're suggesting, oh, there's mortgage. We've never disputed that there was a mortgage on the building at any. There was never been communication. In fact, the plaintiff even assisted with giving resources to help all of the tenants in the building. So far, it's 5 tenants in the building, and they're evicting 3 out of the 5 of them. There is a concern that, is this a retaliatory eviction, being that my client is the only one that has an active storefront, and the other 2 tenants that got evicted never were there or did not actually open their storefronts. The second issue is this a discriminatory situation as to why all of a sudden, out of nowhere, there's no communication for almost a year, and now here we are with this issue of rent and these offers of potential payment plans, and we're sending payment options, and we're sending payment plans, and yet we're still here.
That shows you, Your Honor, how far my client was willing to go to try to help the defendant. And everything was not fine in January. In fact, there was approximately $15,000 that was owed at that point. So if I understand Sister Counsel's argument correctly, they were quiet about it basically, and you know, why did they come looking for their money a year later?
We didn't even get this letter until after this case was filed. Every month, all they send is a notice that says, this is the amount that's due. We never even received the ledger until the second hearing of this eviction.
All right, this is what the correspondent do.
Can
I'm going to, no, go ahead.
Your Honor, I have been speaking with David Grasso this whole time. We've been communicating through text, and from the beginning of me getting there, we all I didn't know about the construction that was taking place across the street. So when the construction started, me and him was talking, he was saying to me like, "Oh, it's okay, everything's okay. I understand, the rent thing. That's why they took the rent down to $250. I sent them like $500, and the person I spoke to said no, don't. We're gonna bring it down to $250 so we can you can maintain. So because we know about the construction across the street, we know everything about the come back around, and you'll be able to pay the rent again. Because before that, I was paying my rent, and when the construction started, it whole business now. Me and Grasso was speaking. He understood it at the time. So all of this just now, like the whole when they did it in January, we were all on the same page. But in the last, like, I guess 2 months, the eviction, all of that was like brand new.
All right. So this is
and one more thing, Your Honor, before yes, one more thing. When I spoke with Grasso yesterday, he said, "Do you have the 1,000 right now today?" I said, "Well, the reason why I don't have it because after I message you responded, so I haven't had the store open. I would have had the store open these days, so I could have made the money to pay him on the 15th. So I asked him, well, can I just give you the $750 next week? Because I had on yes, so he never responded. But I'm like, the deal he offered me, I think I could do it, but I could give him $1,000 yesterday. If he gave me a week, I could have gave him the other $750. That's what I was just trying to say.
and why is your store not open right now?
Well, it's partially because the construction in the front, they put like no parking signs on my. The reason they did because the construction workers.
It's not to the fault. Holding block didn't tell you to stop operating.
No, holding block.
Okay. All right. So this is what
I've still been open. I'm not completely closed, but I do events and things like that to pay the rent and and bring people in because I don't have any walk-through traffic or any traffic that pulls up anymore because people don't want to park out front because they thought the store was closed because of all the construction. So that's why I started doing events to let people know that we are still open.
All right. So this is what I want to do. I'm going to convert this to a non-payment of rent because funds still haven't been sent back and there's still communication about money. So, and it sounds like Holden is willing to accept the money if it's there. It's just a high likelihood that it's not going to come because it's almost at 23,000.
Yeah, if the defendant has 23,000, they would gladly accept it.
I'm sure. So instead of a violation of Part 4s, let's move forward with the judgment by hearing. In the amount of $22,454.81. Although it's not a money judgment, this is what it would take to retain possession. Now, we still have to decide upon a date, and we'll discuss that shortly. But in the event that this is some side agreement occurs, it won't be in violation of Part 4s, nor will we have to come back to court. You would just work that agreement. So the ball is really in your court. It's a big ball. It's $22,454.81. But if you have it, you can pay it and keep that business open. So how much time do you need?
We still need at least 30 days, John, which is what we talked about at the last hearing, with the items that are inside the room.
We have no objection, Your Honor, to 30 days.
Sounds like we have an agreement. Okay. So the court is going to issue a judgment by hearing against, in favor of Holding Block LLC against Filthy Americans LLC and all other occupants, to pay $22,454.81 by July 17th. That's a Monday. And in the event that isn't paid, or in the event an agreement isn't worked out between parties, you will have the legal right, Holding Block LLC, to evict, to file for a writ of eviction on July 18th. As stated earlier, if any side agreements occur, which is totally fine and totally out of the reach of the court, you and Mr. Grasso work something out, fine. Keep it on paper, and Attorney Hammoud won't file a writ of eviction if her client doesn't ask her to. So as long as parties are on the same page, we shouldn't have any issues, but we also have a resolution today. So it's clear, you can pay the funds, and if the funds are paid before July 17th, no issue, no judgment can issue. If there's a payment agreement and a significant amount and they have something worked out, that's another thing. In the event a significant payment is on the application for writ of eviction, I'll immediately file a date for a writ hearing, just to get clarity on the amount. So, does anyone have any questions or anything, any other concerns? I'm sure there's some concerns, but as it relates to the terms of judgment.
No, Your Honor.
Okay, I think this works out for both parties the best. That way, you're not in violation if you collect money, you keep your business open if you pay the amount. So the court prepared the judgment by hearing. I'll give it to you all. We have a judgment.
I do have a carbon copy in the file from Monday's hearing. It's an empty.
Oh, I'm sorry, it's right here. Okay, so I'll fill this out and read the terms out verbatim, so all parties know. Unless you'd like to fill it out.
My handwriting is.
Okay, no problem.
The board doesn't mind, but
Do you object to me filling this out? Okay. And are we adding court costs? I'll leave it at 22,
we'll
4,
leave it
5.
at the 22,
Okay.
454.
All right. So, the plaintiff can apply for an order evicting defendant. This is 4A, I'm scratch out 4B. If the defendant does not pay the plaintiff or the court the amount due in item 2D above, or does not move out on or before July 17th. $2023, obviously. And the amount in 2A or 2D, which would be the total, is $22,454.81. Take our time with this. A defendant, box 5 is checked, where it says the defendant may be liable for money damages after moving if additional rent is owed or if there is damage to the property. For box 6, acceptance of partial payment of the total amount due in item 2D, will it or will it not prevent the court from issuing an order?
Will not, Your Honor.
So, in the event $20,000 is paid, there's still a legal right to evict until the total amount is paid. Whether it happened, if a significant amount is paid, that's another case, but legally, they will have the legal right to do it. No money judgment is entered at this time. Are there any other further orders?
No, Your Honor.
All right. I'll enter this as a hearing judgment. These parties really didn't agree, but sort of agreed. So we'll leave it as a hearing judgment. I'll sign this today. Parties will get their copies. Thank you, both sides for appearing. You all have hardworking attorneys, but it helps to have people with feet on the ground come in and explain a few things. So thank you for your time. Happy Father's Day if that applies. Good luck to your business, both parties. Rent has to be paid, money has to be made to pay the rent. So good luck to both sides, and hopefully I'll see you all on this issue again.
Thank you.
All right, take care.
Thanks, Your Honor.
You're welcome. All right. Party's ready now. On notes. Calling case number 2334-6878. This is Lakewood Manor versus Sarah Dokes and all occupants.
Good afternoon, Your Honor. For the record, my name is P8497 on behalf of plaintiff.
Good afternoon. Yeah.
Good afternoon, Your Honor. Connor Brown, P79949 on behalf of the defendant.
And can we have your name?
Sarah Dokes.
Thank you, Ms. Dokes. And good afternoon to you and your patience. Appreciate it.
Everyone's patience today, Your Honor. I think we hoping the court will adjourn this to
July 14th.
that is doable.
Pick the right week. I mean, our parties in agreement of this adjournment.
We are, Your Honor. We do need to take some time to prepare some documents and some receipts with the ledger, and also we are stipulating to an escrow order for the month of July, in the amount of $738
Okay.
for rent.
Yeah, that's correct. Yeah, this is going back to like 2017, so there's quite a bit to sort through.
An escrow order will be granted. You can pay the rent. You're basically buying time, and parties are in the same position they were a month before. So I have no objection to this. Do you have an escrow order? I can put one together.
We have either the escrow or the.
I have a blank order form.
Yeah.
You can approach. Officer Coates, grab it for you.
We do a written adjournment order as well, or will that?
You can
just
do
be
it on the
done
same.
On the same order, okay.
Yeah, you can just do it on the same order. Sounds good. So July 14th, what time? You want to go a little later in the morning?
Sure, yeah, we could do 10:30 or something.
In case you catch a little traffic. Your attorney is traveling a long way to represent you. Ms. Dokes.
Hello. My favorite. All right, I guess we'll get this written up and.
All parties have notice, so you may receive something in the mail. Put it in your calendar today. If you draft that up and get it to us today, we'll get it back to you. If not, it's not fatal. It's up to you and your time.
All right, might send that email.
Okay, well, you can see it.
Might do it next time.
All right,
Thank you, Judge.
Thank you, Ms. Dokes.
Thank you.
Attorney Brown, Attorney Dye.
Enjoy your weekend.
Enjoy your weekend. Happy Father's Day. It's applicable, you know? All right. I think this concludes this docket today. Mr. Moon.
Yes.